A16738562.
Good morning, Your Honor. Eric Tran on behalf of defendants.
Good morning, Your Honor. Shawana Johnson on behalf of plaintiff Russell Zitch.
And this is defendant's special motion to dismiss plaintiff's amended complaint pursuant to NRS 11.190(4)(e) and NRS 41.660. Counsel, you prepared to go forward with argument?
Yes, I am, Your Honor.
Proceed.
Your Honor, we've been down this path before. Despite this court giving plaintiffs another opportunity to amend the complaint to make it valid, their amended complaint is still invalid and fails as a matter of law. We're ready to submit on our briefs. I'm not sure I have a lot more to add, but I did want to highlight a couple of points. The first point is quite obvious, is that the amended complaint is still barred by the statute of limitations. Now, this court ruled in its previous order that the plaintiff's sole claim for intentional infliction of emotional distress accrued on or before April 2nd, 2013.
Okay. My concern previously, counsel, was whether this was a continuing tort. I mean, that was the issue. Whether it accrued on that date or not was not determinative to me. The issue is whether intentional infliction of emotional distress is a continuing tort. I made it clear to both counsel that that was the concern I had. I granted the 12B5 motion with leave to amend. Neither party has really provided me with any case law on that issue.
Well, Your Honor, that's because there is no case law in Nevada. Nevada doesn't recognize the continuous tort theory. So this notion of the continuous tort, it just doesn't exist in Nevada. There is case law from other states that do address this so-called continuing harm theory or continuing tort theory, and that's addressed in our reply brief. In cases where, in other jurisdictions that have considered the continuing harm theory, has stated that even if there is a continuing harm, the accrual dates begins from the earliest date in which you discovered that there was a breach. And again, in this case, the court ruled in its previous ruling that it accrued on April 2nd, 2013. There's really no way to get around that.
There actually is a way to get around it if it's a continuing tort.
Well, that, again, Your Honor, that is not recognized in Nevada, and in plaintiff's motion or plaintiff's opposition, they haven't submitted any case law that addresses this whole continuing harm theory, and that's because there is no case law in Nevada.
Your Honor,
Hold on. Are you concluded, counsel?
No, I have not concluded yet.
Continue.
And in their opposition, another way they try to get around this, the statute of limitations, is by arguing that the Supreme Court already made a ruling that their IIED claim is timely. Well, that's not true. We submitted.
I agree with you, counsel. Okay. I did not read the order the same way as opposing counsel's reading it.
Right. And so the second argument, which we think is just as important, is that this is the type of case that highlights the importance of Nevada's anti-SLAPP statute. The anti-SLAPP statute was designed to protect litigants from retaliatory lawsuits, just like this retaliatory lawsuit we have here today. The only reason why my clients is facing this lawsuit is because of their conduct in the underlying divorce litigation. There are written statements to the Nevada State Bar, and also their rights to defend themselves in this litigation. And if you go through the analysis that we did in our brief, it shows that the conduct is clearly protected activity under the statute. And again, the second part of the analysis is that whether or not plaintiffs are likely to prevail on the merits, and we've demonstrated that the statute of limitations applies in this case. And so for those reasons, Your Honor, we believe that our motion to dismiss should be granted in its entirety.
Counsel?
Thank you, Your Honor, and I apologize for interrupting. There is case law in Nevada on the continuing tort. I cited it on page 9 of my brief. That is the Williams versus UMC case. And I apologize, Your Honor, I don't have the case with me. That case dealt with, if I remember, an actual continuing tort, and it might have had the attorney-client element to it as well. Nevada,
counsel,
the case law
counsel,
I found.
I read that case. I pulled that case.
Right.
And I didn't I didn't see it referencing that it being a continuing tort.
I read it to reference that the issue in that case was whether, if you have a tort, whether you can sue at that time or whether you can sue after the series of torts was completed. And that's what I cited the case for, that you can sue when the last act of the continuing tort is completed. And again, I apologize, I don't have the case in front of me.
desk.
However, Nevada law, if the court were to accept, we have to remember, this is a motion to dismiss. If the court were to accept these allegations as true, the court may not believe that ultimately Mr. Zitch could prove his case. However, if the court accepts the continuing tort theory, which is alive and well and valuable, whether or not the Nevada Supreme Court has a plethora of case law on it, if every allegation in the complaint is accepted as true, then this motion has to be denied. When we were here last, Your Honor instructed counsel to, you gotta put something more in your complaint about why this isn't barred by the statute of limitations. So we went back and I explained it more about the entire history of this case and about what the defendants did in this case to continue their process. As we mentioned at several points, the initial malpractice was enough. However, when you continue going through the process of calling your client, the difficult one of blaming him for the mistake, of causing him, not paying him his damages back, that is what would qualify. Again, at this point, we can't assess whether ultimately a jury would agree with that. However, we can assess whether the allegations are in that complaint. And I agree that there's a dearth of case law on the continuing tort, but from what my analysis, it exists under Nevada law.
Well, I read Williams versus University Medical Center of Southern Nevada. It's a district court case determined by Judge Pro, and I didn't see where it references a continuing tort. I mean, matter of fact, the causes of action in there, other than maybe slander, were, more contractual. But I didn't. I'll reread the case. I'm going to take this matter under submission because, to me, that's the issue in the case, whether it's a continuing tort or not. Obviously, your clients were well aware, from the beginning when this, because you went to the state bar, you did all kinds of other matters. And the issue, quite frankly, is if in Nevada we do not recognize continuing tort for intentional infliction of emotional distress, you're probably going to be out of court.
Right.
I mean, the Supreme Court's already ruled on your other causes of action. Under 11.207 is being barred by the statute limitations. It left as an open question whether the statute of limitations had run as to the intentional infliction of emotional distress, because that's a different statute. It's 11.190 paren 4 paren E. So I want you to make a complete argument, but I do intend to take this under submission.
Okay, would you like us to do a small supplemental briefing?
If you got the issue to me, and this is what I expressed to both counsel last time we were in court, is whether intentional infliction of emotional distress is a continuing tort. Okay. And just, opposing counsel's position is that Nevada doesn't recognize continuing tort, period. So I did read the Williams case, and I intend to reread it again. But if either party wants to submit supplemental points and authorities, I'm going to take it under submission for 2 weeks, and I'll render my decision at that time.
Okay, Your Honor, I did want to clarify one of my arguments. What we're saying is that Nevada doesn't recognize. What we're also saying is that Nevada doesn't recognize the continuing tort theory as to toll the statute of limitations. And this is an argument that we've been down this road before, where Nevada only recognizes tolling when it comes to concealment or fraud. And continuing harm is not recognized pursuant to Nevada law.
Well,
it's not a tolling argument. It's a flat-out tort argument.
Right, and what she's saying, it's not told. She's saying that the harm continued. And beyond, Typically, it's accrued when you find out about it, when the harm results. That's typically when it accrues. And what opposing counsel is saying, that this was continuing, and during the continuance, the harm had not accrued.
And I do understand that concept.
So she's not necessarily arguing a tolling argument. She's saying the part of the cause of action is the continuing tort aspect of it.
Your Honor, and I do want to say that I did read Williams, and I agree with the court that it didn't even mention continuing harm, and I don't think that case applies.
And that may very well be true. I'm going to reread it, and I'm going to give both parties the opportunity to file supplemental points and authorities.
Thank you, Your Honor.
Thank you, counsel. Continue it 2 weeks for a decision.
September 20th, 9 a.m.
Okay, did you need us to appear as just
I would probably appear.
Okay. So, I have 3 hearings that day.
Just if you're going to be late, I can trail it. Just notify my chambers.
Okay. 9 a.m. you said, sir? Thank you.
Realize I'm kind of an outpost over here. On page 13, Shadan LLC versus David Alessi, case number A1775